treaty depredations that's happening this very second, this very moment, every day.
Lilias, Jarding. We are waiting, we were patiently waiting.
Thank you. Thank you. We were having some technical difficulties. My name is Lilias Jarding. I'm with the Black Hills Clean Water Alliance. We're a nonprofit group based here in Rapid City, and we work on protecting water, specifically from mining, but also through the related topic of climate change. Let's see. Mhm.
Use the arrows up and down there.
This one. Okay. So this is what we're trying to resolve before we even think about anything in the future. There are over 1,300 old mines in the Black Hills. Most of them are not reclaimed. Some of them are small, some of them are large. There's quite a mix, and they're for all sorts of metals and gems and a variety of things. There's the old Homestake mine they call the open cut by lead, or actually in lead. There's the Superfund site of the Gilt Edge gold mine. The picture is at the top right. The problem they have there is they can't stop the water from being contaminated because the mine hit groundwater, so they can't stop it from flowing, and it gets acidic. There are also about 170 abandoned uranium mines and prospects in the southwestern Black Hills. The largest one there is on the lower right. That's called the Darrow Pits. And then there are another 100 or so in Harding County. And these mines sit open and drain into the waterways. As of this May, there were all the areas that are in purple, brown, and yellow are active mining claims in the Black Hills. 261,000 acres of active mining claims. This has gone up exponentially in the last few years. And it is 20% of the total Black Hills that is under these claims. The claims are set up under the 1872 mining law, which is over 150 years old and has never really been amended. And what it basically says is that you can stake a claim, and you can be an individual, a company, a government. You can stake a claim, and that under the law gives the person a right to explore, and if they find something, to mine. Okay, it just speeds up the process of getting to mining. So this is what we want to prevent. This is the only large-scale open pit mine right now in the Black Hills, the Wharf Mine by Lead. And this is a picture taken from an airplane that we did about 1.5 years ago. Here's another picture of the mine. It's 7.5 miles around. This is just a part of it. And it's had about 189 toxic spills since it was started in 1983. So I want to quickly tie in the climate crisis into the situation because I think people have a misconception often about what's going on with that and how it ties to mining. It's not just about a warmer planet, it's about more extreme weather and other things, but for our purposes here in the Northern Great Plains, more extreme weather is the big issue. In South Dakota, there's been a huge increase in tornadoes and in the severity of those tornadoes in the last 25 years. And those of you who lived here for a long time, or in other words, those of you who have gray hair, may remember the difference, may have seen the difference, okay? The difference that I've seen, and I've been in the Black Hills off and on since 1979, is that there are more floods in the last 25 years compared to from 25 to 50 years ago. So according to research by Texas A&M University and others, much of western South Dakota is particularly vulnerable to climate change, partly because of the extreme weather, but partly because there are things that make our communities less resilient, less able to recover from extreme weather. So when they looked at this vulnerability, they looked at all these things. And this is the map they came up with in terms of overall climate vulnerability. The darker areas are more vulnerable. And when they looked at just vulnerability to extreme weather, this is the map they came up with. The darkest color is the most vulnerable to extreme events. So it's pretty much all of West River. The first time I saw this map, I just went, okay, so some of you may be feeling that way too. So one of the proposed solutions to climate change is electric vehicles or EVs. Electric vehicles currently, most of them have lithium batteries. And the batteries weigh hundreds of pounds. The rush to mine lithium has, by the Biden administration, has ignored the impacts on rural communities and on indigenous communities, which are particularly vulnerable to lithium mining. So more mining is not the way to reduce climate change. And the reason is very simple. Mining is a large contributor to climate change. 10% of all carbon emissions worldwide are from mining. Okay. So this is per United Nations Environmental Program. It's not just some radical group that made this up, it's the UN. They're radical in their own way, I guess, but. So the green energy revolution as it's currently planned would require lots more mining. Basically what this means is that the pollution burden is moved from the tailpipes of cars and factories in the urban areas to the mining and the emissions from mining in the rural areas and the destruction of the landscape. So the bottom line from this is that you can't mine your way out of the climate crisis. We need other kinds of alternatives. And there are a few people here I've seen who were at the conference we had this past summer, or we had another one last year, talking about these specific issues and how do we resolve them? Because we don't want the climate crisis. We don't want lithium mining. So what do we do? What do we offer for solutions? And there are a lot of people who, I'm not going to answer questions till I'm done. There are a lot of people who are working on these questions, scientists, policymakers, et cetera. And there's a lot of research underway, and they're trying to come up with new ways of dealing with these things. So as far as lithium mining in the Black Hills, there are 9 lithium operators that we know of right now. Most of the claims are in the central and the southern Black Hills. There are also 5 state mining licenses which are on private land. And there's one recently active mine in Lawrence County in the northern Black Hills. And these mines that are not on federally controlled lands, that are under only state laws, are very easy to get. So a mining license for lithium on state-controlled land is $100 a year for a license and a 1-page form. And then you have to file a bond. So uranium mining is something that more of you have probably heard about. There's past uranium mining. I mentioned the number of old mines and prospects has contaminated the Cheyenne River, starting in the southwest corner of South Dakota and the Black Hills. Besides the actual mining, there were also mill wastes, which are from processing uranium, which were spilled into the river. And this was all stopped in 1972. It was in the 50s, 60s, and 70s. But there's continued contamination because radioactivity and the toxic materials are there, and the uranium in particular, with the radioactivity, has a lifetime that's basically, for our purposes, permanent. There have been impacts on the Pine Ridge Reservation that have been measured. It hasn't been registered or measured. Scientists haven't looked at down the Cheyenne River to the Cheyenne River Reservation. So companies tried to restart uranium mining in the late 1970s. And a coalition of native and non-native people got together and worked together and stopped the proposed start to uranium mining at that time. And there are a few people here who can tell you more about that. Currently, the big proposal, the one that's been around for 15 years, is the Dewey Burdock project. Now it was owned officially by PowerTech. PowerTech is now owned by Encore Energy. It's 12,000 acres right along the immediate edge. Some of it's up in the hills, some of it's down on the plains, along the western edge of the Black Hills. It would use in situ leach mining, which involves pumping a solution under the ground through large numbers of wells. In this case, their plan is for 4,000 wells, and then pumping the solution through the water, and it picks up the uranium, and then pumping it back to the surface and processing it. The project will also destroy cultural resources. This is from another project, another in situ mining project, but it shows what happens when they start drilling all these wells. And they have asked for 9,000 gallons per minute of water for this project. That's a third, again, more water than Rapid City uses. Huge amounts of water. In order to start mining, the company would need 10 permits. They planned on starting mining in 2009. They've been held off by the Oglala Sioux tribe and citizen groups and other organizations throughout western South Dakota and beyond. They have 1 permit so far, and that is up for renewal. That's a permit to handle radioactive materials from the Federal Nuclear Regulatory Commission. But the bottom line is, it's been 15 years, there's no mine. Okay? Citizens and governments working together can slow these things down. So half of the Dewey Burdock project is in Fall River County, which is the extreme southwest county of South Dakota. They had an election in 2022, November 2022, and the citizens in the county voted 56% to 44% to declare uranium mining a nuisance. That's the official language. It's more than a nuisance, but that's the language in the laws. So this citizen action makes uranium mining illegal in that county. But that'll be tested in court at some point. And one of the reasons we can safely say that is because there are other new uranium projects which are starting up in the southern Black Hills. And these are in a particularly important place. The company is called Basin Uranium. They're Canadian. they have two projects near Edgemont. One of them is the Cord project, which includes Craven Canyon. They're developing an exploratory drilling project. They haven't applied for any permits yet, working on that. I'll talk more about that in a moment. And the name of their subsidiary company that's applying for the permits is Clean Nuclear Energy Corporation, which I can't say with a straight face. So I just call them CNEC. So Craven Canyon is a world-class site for pictographs, petroglyphs, and other historical and cultural things. Drilling, if they got their permits, would occur within hearing of the cultural and historical sites and within the view shed, what you can view of those sites. So illegal mining in Craven Canyon was stopped in the early 1980s. The case about that went all the way to the South Dakota Supreme Court. It was under an organization called Black Hills Alliance. And one of the attorneys that was responsible for that is Andy Reid, who's in the room. But there have been a lot of attempts to protect Craven Canyon. And these include the case in the 80s. These include the fact that parts of the area are on the National Register of Historic Places. Parts of the area are under a state designation called Special, Exceptional, Critical, and Unique, or CQ, thank goodness there's an abbreviation, status. So that's a federal status, a state status. The state status protects from mining, but it doesn't protect from exploratory drilling. And a small area is under a federal mineral claims withdrawal, which I'll talk more about what that means in a minute. But the withdrawal, the safe space, is surrounded on three sides by the proposed drilling project. So this project, the overall thing is the Cord project. And Basin CNEC want to drill on both state and federal controlled lands. They call it the October Jinx exploration project. The Cord project as a whole is almost 4,000 acres. And tribes, individuals, groups, and governments can participate in both the state exploration permitting process and the federal exploration permitting process. So here's how. On state land, because it's uranium and because it's on land that the state controls, there will be a permit process that includes a hearing. As of now, what the state is doing is they are getting a lot of formal input from the state historic preservation officer, but have not involved the tribal historic preservation officers. However, individuals, groups, and governments can intervene, formally intervene in the process and be a full participant. Where I've been an intervener, it means I can call witnesses, I can question witnesses, I can submit documents to the process. And in terms of being an intervener, individuals don't need a lawyer. I just went and did it. Groups and governments do need a lawyer. So if you're thinking of getting involved, you can just do it by yourself, or you can do it through a group or government, and you need a lawyer. So the bottom line on this one is inform people about this and plan now so that people can be interveners. We had 200 interveners when we did these processes on the Dewey Burdock project 11 years ago. But the trick is that there's only 20 days from when the state issues a notice about the project to when a person or a group or a government has to intervene. And the actual intervening is really simple, but you have to be quick. The federal part of the project is on federally controlled land run by the Forest Service, and it has proposed to let the project, the drilling project, go ahead without further environmental review. That's called a categorical exclusion. There will be an opportunity for tribes, local governments, groups, and the public to comment, just to comment, But it's important to get ready for that too, to let people know that there will be an opportunity to comment. And to comment, get all your groups, individuals, governments, tribal governments, ready to comment, to block the categorical exclusion, to draw the process out and hopefully stop it. The trick here is that if someone hasn't commented in the initial part of the process, they lose the right to be involved in legal activity later. So people have to comment. So quickly, I want to just talk a bit about the gold exploration. Some of it's ongoing at this point. The Dakota Gold Company is drilling by Maitland and on the east edge of Spearfish Canyon in the northern hills. They have a state mining permit for mining, not exploration, but for mining right by Spearfish Canyon, which is a beautiful place. I hope that most of you have been there or that you get there soon. The Forest Service also gave permission for drilling in what's called the Golden Crest Project, which is on the west side of Spearfish Canyon. And then there's also a project called the Ponderosa Project, which is also exploratory drilling for gold, right near the Flandreau-Santee Sioux tribe by Cheyenne Crossing. And at some point, that project will also come open for comment. So there's a company named F3 Gold, which has 2 active drilling projects. One is the Newark project, just west of Custer. That was actively opposed by the Oglala Sioux tribe and the Custer Public and our organization and Indian Collective and others. But the Forest Service let it go ahead, again, under this categorical exclusion where there wasn't full environmental review. There's also the Jenny Gulch project for F3 Gold. This proposes drilling right on the edge of Pactola Reservoir, which is Rapid City's water supply. It's also Ellsworth Air Force Base's water supply and communities and tribal members all the way down the Cheyenne River. There was a huge public outcry, hundreds of comments against it. The city of Rapid City came out against it. Ellsworth Air Force Base came out against it. And so what happened was the Forest Service proposed a mineral claims withdrawal. So I mentioned this about Craven Canyon, but here's what it is. It's a way under the 1872 mining law to stop mining and drilling on federally controlled lands. So what it is it's not about withdrawing minerals from the ground. It's about withdrawing mining claims so the area can't be drilled or mined in most circumstances. So those claims go away that give people under federal law the ability to explore, drill, and mine. So the mineral withdrawal is proposed on Pactola Reservoir area, about 20,000 acres. It would stop the Jenny Gulch project for 20 years. Over 1,900 people commented on this withdrawal. 98% supported the withdrawal. So now we're waiting for Secretary of the Interior, Deb Haaland, to make a final decision, which could happen anytime. And there's also work on extending withdrawals to cover the whole Black Hills. So all this is heavy, right? There's been some bright spots, some things that went well, but it's still kind of heavy to know this is going on. So I always tell people, here are some things you can do. You as an individual, you as a member of a group, you as a member of a tribe, can do these things. Find out more. I'll put our website up in just a moment. Talk to everyone you know about this. Okay? It's really important. There are still a lot of people that don't know what's going on. You can write comments when there are opportunities to do that. You can intervene in the process when there are opportunities to do that. I or one of our staff people can come give a presentation, short or long, in a variety of places. We put up information tables, about 24 a year. We need help always staffing those. And then we do events and actions. So my bottom line in working on this for a long time is that alliances work and opposition works. The more people oppose a project, the more opportunity for it to be slowed down or stopped. And these are some situations where projects have been stopped. Okay, uranium mining was stopped in the Black Hills in the 79 to 81 time period. Uranium mine was stopped in northern Colorado. Metals mining has been stopped in boundary waters in Minnesota. The New World mine in Montana was stopped 30 years ago now, but Crandon mine in Wisconsin was stopped, particularly due to the activity of two tribes. And there are lots more examples, but these are the ones that come to mind most quickly. And so now you see our website. We're on Facebook, X, Instagram, YouTube, and soon Blue Sky. And that's my personal email address. You're welcome to get in touch with me. You can also, if you lose that, get in touch with me through our website. And I look forward to hearing from you. Do we have time for questions, Phil? Okay. So now there was a question over here a long time ago. Yes. I'm hard of hearing, so you'll have to speak up.
Grab the microphone and state your name and where you're from.
Tokaya Tunkashla Wopla Waku, Lemia Chamatonia Hemia, Chunkbe Opia Matiwa. My dear relatives, before we say anything, we thank the Creator first. My Lakota name is Bear Woman, and I am from Wounded Knee. My English name is Joanne Spotted Bear. First off, I worked at Tesla, and the battery packs are 300 and they're rechargeable and they're only about that big. And yeah, they do use uranium, and when it starts on fire, it doesn't go out until it completely burns out by itself. The second one is the United States went bankrupt in 1933. Roosevelt fired Congress, accidentally fired himself. And as the great Lakota nation, Teton, Oceti, Sakowin, however you want to call us, why isn't that ever questioned? Because according to the studies I did, the Doctrine of Discovery, first Clearfield Doctrine says that a corporation cannot supersede a nation. And that bankruptcy supersedes eminent domain, manifest destiny, and the Doctrine of Discovery. At the United Nations level, I was at the United Nations level and got kicked out. Also went to jail in Washington, D.C. I have a big mouth and can't shut up. But anyway, what I'm trying to say here is these uranium mines are all corporations. And our treaty 1851 supersedes any corporation in this country, including Donald Trump. And our tribal council, the 638 contract, is a corporation. It is not sovereign. You lose your sovereignty because you're duly enrolled member when you work for the United States government. And when I say things like this, I feel hurt in my heart because my own Indian Lakota people get mad at me for telling the truth. There's times that I feel, I really hate to say this next part, but here it goes. I wish I was dead because I come from Wounded Knee. And our people stood up for what was right. And December 29th, 1890, that reminder is going to be here in a couple more days. And I often wonder, when are you going to stand up and Blahichiapo and be strong and help our people to live? Because alcohol, drugs, and things like this contaminating our waters, destroying not just us, but our people and our next 7 generations. And there ain't gonna be no next 7 generations if we can't stand up now and ask the United States, where is your corporate charter number. 1933, Roosevelt Fair Congress. So you don't have no sovereignty. You don't have a treaty no more. This Clearfield Doctrine clearly says that itself. We didn't write it. They did. We shouldn't have to be in trouble, and here's the kicker. One time our people said if we ever stood up for our Lakota people that you'd lose your home, your finances, your job, and you might even lose your kid and they'll kill you. Well, guess what? I lost my home, my job, my finances, and 2 of my sons are dead. And I'm waiting for them to hurt me because of what I'm saying right now. And it's true among our Lakota people that this government does not like you. You are not Americo Vespucci's grandchild. You belong to Sitting Bull and Crazy Horse. So until you get the truth right and accurate, then these people like this are going to continue to destroy us, our future, and our way of life.
Any, ask questions of the presenter? You need to ask questions? If not, I guess we're done.
Thank you all.
Okay. We're gonna bring our favorite presenter. Andy Reeves. Challenge the doctrine of domination. I just wanted to ask a question of the presenter because they come up here to present what they have, their topic area. And if you could ask them, they'd probably give you a little bit more insight.
Greetings, everyone. Yani Octei. Most of you, I think, know me. I speak pretty regularly at these things, and I try not to repeat myself. I'm a Sioux international human rights lawyer, and I've been working in federal Indian law for 50 years and international human rights law, indigenous peoples law for 10, 20 years now. And have been counsel for the Oglala Sioux tribe on occasion, most frequently I'm the in-house counsel for this man over here, essentially, for free. He hasn't paid me anything yet, right? No? Okay. But anyway, I've been allied with Native people, particularly the ones that occupy and have occupied this area for some 50 years. Phil asked me to talk on the doctrine, what is called the doctrine of discovery. Steve Newcomb calls it the doctrine of Christian domination. And, how I can do that. Great. I call it the doctrine of colonial theft or imperial theft, because what it is, it's the basis of the claim that the invaders from Europe have. It's a so-called legal basis that they have for claiming Indian land. But before I'm doing this, I had one thing I wanted to do. The Makoche people just left. I went to they're a great organization, and I went to one of their conferences, and I picked up this T-shirt here, and I got kind of carried away and got an extra large. Is there somebody want a free T-shirt, extra large, unused? Okay. Sorry about that. It's a great organization. I'm a T-shirt guy. All right. So what I have a few slides here, but I don't want to spend a lot. Usually I do a whole bunch of slides. I've got about 1/3 of what I usually do. I cut it way back because Phil wanted to present this as a real proposal as to what we're talking about. So I wanted to kind of spend my time here. See if I can, there we go. First thing I usually say is for several reasons. I'm a Sioux, I'm a lawyer, I'm an old guy. You shouldn't trust anything I say. So you need to think for yourself, all right? I got a call last week from, I'm not gonna say who it is, but from a tribal attorney somewhere, in-house attorney, upset with me because she said that some attorneys given the Treaty Council people information and they're raising hell. So she was accusing me of inciting a revolution or whatever on the reservation. And so I tried to explain to her that all I do is I present information. I don't tell anyone what to do. And if she has a problem with the Treaty Council, she needs to go to them. So that was a call at about 7 in the morning. I was still in bed and woke me up, but we got it worked out. So the basis of the doctrine of discovery, I'm going to call it what they call it, what the Ocetis call it. The doctrine of discovery is this doctrine of the law of nations, international law that existed hundreds of years ago. And it still exists today to a certain extent. The way it is under international law is that if a piece of land or territory is unoccupied, then the discovering nation or whatever people can go in there and occupy it, take it, right? So that's fine, nothing wrong with there. The problem that they had was that when they came to Turtle Island into Oglala, which is the Americas, what we call the Americas, there were people living there. There were some 60 million or more people that were living, some say up to 100 million people living in the Americas at that time. So how were these people from Europe that were jealous and wanted all this beautiful land, the Garden of Eden, that how were they going to get it? They had to come out with some kind of legal argument for doing that. And so they're the imperialists, and they came over not just for settlement, but also to rape the land and the peoples that were here. They initially enslaved native people. By the way, slavery of Indian people was ratified, there was a case that went up to the U.S. Supreme Court, I think it was around 1834, on whether or not an Indian woman was still a slave, and the U.S. Supreme Court said, yeah, she was. So slavery of Indian people continued in this country. It was legal until at least 1834. But anyway, so they enslaved the native people. They put them to work in the mines, and the women taking care of the Spanish there and giving them children being raped. And then they used the argument that they were trying to do it for the benefit. It's benevolent genocide. They were doing it for the benefit of the native people there because they were bringing civilization to them. They were savage people, supposedly. Although if you read the accounts from back then, particularly that by a guy named Bartholomew de las Casas, who wrote a book on this stuff at the time, he was there for 30, 40 years, right? He came out on Columbus's second voyage and witnessed the genocide that was committed on the Taino people and others of the Caribbean for the next 40 years. And he wrote about it, and one thing he remarked on was that the native people that were there were far cleaner and well-behaved than the Spanish. People from Europe were dirty. One of the reasons, you know where perfume comes from? From the French. You know why the French use perfume? Hide their smell. They didn't bathe. They just put perfume on, right? My wife keeps trying to put perfume on me, and I think I know why. But anyway, they said that native people were savages, that they were uncivilized, and then the Pope sanctified, not only authorized, but sanctified. They said that people from Europe were doing God's will by coming over to the Americas and bringing Christianity to native people to replace their own spirituality. And so that was the excuse that they gave for coming and taking the Americas. The other excuse that they gave was that there was plenty of land over here, that that they said the native people weren't using because they didn't actually put fences around it. And they didn't claim it as private property. And so they said, if you're not going to claim ownership, of course, native people didn't recognize private property in that sense because you can't own Mother Earth. You can't own the buffalo. You can't own the parts of nature that are your relatives. You can't own your mother. But the Europeans had a whole different way of looking at property, and they said God gave property to humans, and God told humans, this is out of the Genesis, God told humans, you go out and exploit it, benefit. He cursed the humans for eating of the apple, and they learned sin. They learned the difference between right and wrong. And from the tree of knowledge, this is all in Genesis. So he kicks them out, and he curses women to have pain in childbirth, and he curses men and human beings to go hungry and have to work. And he says, but I'll give you the earth. Everything in the earth is yours to fulfill my curse. And so, and this is all, by the way, this is not old stuff. The basis of Western property law, private property and all that, comes from a guy named John Locke, who wrote a book on that called, and in his second treatise, he goes right back, it's like a commentary. He goes right back to this Garden of Eden story and the curse. And he says that in raping the earth, taking things from the earth and using it and taking it to yourself, is that you're fulfilling the curse of God. And so, and you see that even today. And so that's the basis of our Western property law. That's why we don't protect nature. We regulate the exploitation of nature, which is totally different. So and all of that is still the law today. I'm being a little bit long-winded, but all this is the basis for the doctrine of discovery, right? So they said Native people refuse to say that they own the earth. They said, we don't own it. Nobody can own it. Well, the Europeans said, well, we'll own it and we'll take it. And they did. So they passed a law saying that because you don't own the land and because savages are uncivilized people should not own the land, that the superior race, the white people from Europe, are a superior race in civilization. And they have, therefore, because of their superiority, they have the right to take and own the land. And that they're going to bring their civilization and their ways, the Oceti ways, to the native people for their benefit. It's going to do you good. And they're going to teach you the ways of private property. And you'll see that even in the treaties. All those treaties, you see the allotments there. What's the allotment all about? It's privatizing land. And that goes back to this whole theory about owning and exploiting the earth as a command of God. You'll even see that in the law of nations. That's there. And so then the third reason that they gave for being able to take the land of native people for the doctrine of discovery is that only Christians could own land, in their view. And so because the native people were heathens, non-Christians, then they had no right to the land that they had been occupying since time immemorial. So those are the reasons behind the doctrine of discovery. So that started in 1492, and then it went on up all the way through. It was used by the Spanish and then by the English and the French around the world, not just here, but around the world to take the lands. You saw this in Australia too. And so that was the imperialism. That's the empire. So when they created these empires, that was their argument for the right to that. And so the United States, when they got their so-called title, they had wars with Spain and the Revolutionary War with England, and then they had wars with France and so forth. So you get the Louisiana Purchase, you get the lands from Spain after the Spanish-American War. And so they got all these cessions of this colonial title, of this imperial title, and they put them together. They didn't pay any attention, though, to the native nations that were already there and not always been there. They just put them together. And so that whatever title that these imperial nations had, they then went down to the United States and inherited it, right? So the United States is actually a successor colonial state. And to this day, it is the colonial empire that rules over 500 native nations here, as well as Hawaii, the nation, the Kingdom of Hawaii, the Taino people in Puerto Rico, the people in Guam and elsewhere. So the United States is a colonial successor, what I call a successor colonial empire. And in creating these laws, you know, normally when there's an invasion, and there was here, you end up in wars. We had the Lakota Wars and other things went on here. The colonial powers, the invader, they want to make everything legal. You know, when Hitler went over and he killed off all the Jews and the gay people and the gypsies and so forth, when he murdered them all, you know, that was legal. Under German law, that was legal. They passed laws making everything they did legal. They passed a law, it's called eugenics, where you purify the race by killing off inferior people. Where did they get that law from? They got it from the United States. The United States had a law saying that they could sterilize disabled people, particularly mentally disabled people. The Germans got that from us, and they used it in order to kill people that were struggling. And so that's called lawfare. You're conducting war, not just by shooting somebody with a gun, but you're conducting war by using the law. And that's what I see federal Indian law is. That's my definition. I'm a lawyer. I'm doing this stuff a long time. I teach this stuff at a law school in Denver at the Stern College of Law. I have been for over a decade. But they use law as a weapon. Use law as a weapon. It's called lawfare. And I see federal Indian law as that. It's the domestic law of colonial occupation. And you hear almost no lawyers, federal Indian lawyers, any other lawyers in this country who work in this area. Very few of them. There's only a handful of us actually have this analysis and talk about this. And that's because the United States, the colonial power, has been so successful in converting minds and brainwashing native lawyers as well, that this is legal, this is all good and just, and so forth, when it is entirely illegal under international law. So these are the books, they use these in the law schools to justify, this is their lawfare. They have it all down. So it's a law of colonial domination and slow, what I call slow genocide. Gradually forcibly assimilating native people and then taking their resources. And so we're at the main case that started this was known as the McIntosh case. That was called the Marshall Trilogy. Started in 1823, and the last case was in, I think, 1834. So during that 10-year period, they created this law, this lawfare, this colonial law, the U.S. Supreme Court. And the main one was the McIntosh decision, which was decided by the Chief Justice. So after the McIntosh decision and the other one's called Cherokee Nation and Worcester. In those decisions, they created three doctrines. I call them colonial doctrines. One is the doctrine of discovery, theft. And in that one, it said that because Native people didn't own the land that they were on, and because they were heathens and savages that had no right to the land, that the land was therefore declared unoccupied. And because it was unoccupied, then they could use the international law of nations to say, well, if the land is unoccupied, then we can go take it. And this argument, this case, this McIntosh case, was then used and cited by Canada. It was cited by Australia. It was cited in Africa. You see the same case coming up around the world. So this cancer that was created by the United States in the Supreme Court spread throughout the world and has been used to oppress Native people throughout the world and take their lands and resources. Now, because the doctrine of discovery, what do you do if you come into an area and there are people living there, right? The 100 million or so Native people live. What do you do if you're an imperial colonial nation? Under the law of nations, you're supposed to take care of them. You know, you have a responsibility to them, all right? And so how did that manifest in U.S. law, in federal Indian law? It became what's known as the trust doctrine. And the trust doctrine, believe it or not, says we have to lord over, we have to rule over Native people because they are incompetent savages. They're not competent to make decisions on their own. And that's the law today, by the way. That's why you have trust land. That's why you have trust accounts and so forth. It's because the United States is the guardian, the great white father of all native nations and peoples, right? And that's fundamental Indian law right here today, right? And so what happens then if you take authority over the wards, over your children, right? Or your, then the guardian under trust law, American trust law, Oceti trust law, European trust law, you have total authority over them. They're children, they can't make decisions. They have no right, they have no standing. You don't even have a right to say anything because you're incompetent. And so what do? They come in and say, well, we have total authority. We make all the decisions over them. And that's called the plenary power doctrine. Plenary means absolute, the absolute power doctrine. And that's still the law today. We talk about this Indian Child Welfare Act case that came that said that the states could not take Indian children. Everyone was saying that's a great decision. If you read the decision and the way it was decided by the U.S. Supreme Court, the U.S. Supreme Court said that the states can't take the children because the United States has plenary power over Indian people. That the states are violating the rights of the federal government, not the rights of Native people. That's what that case says. And you'll see the federal Indian lawyers go out there and you see the people, the NARF and the other people that argued that case, they said it was a great victory. It wasn't. It was a horrible decision because it was based on the plenary authority of the United States, that they are the only ones that can approve the adoption of Indian children, right? And right before that, there's another decision came out a few years before that. Everyone says, oh, it's a great decision. It's the McGurk decision, where they said that the Creek Nation is still alive, that the territory is still there, because the federal government hadn't taken it all, clearly taken it all. And that's why Tulsa, Oklahoma is now on Indian land, the Ocmulgee Creek. And so you read that case, it looks good, except they go through and they talk about everything that they did to the Creeks. They stole their land, they stole their government, they destroyed their courts and replaced it all with the IRA type things, with Western government, Western courts, took their land, destroyed their language, destroyed their culture, and so forth. But the last thing they didn't do, this is the opinion by Gorsuch, he says, the last thing they didn't do is Congress didn't pass a law, an act saying we're taking your territory as a matter of law. So that maintained their jurisdiction, even though they were basically hollowed out inside. There was nothing inside the nation. It was no longer there. It had all been replaced by Oceti's with their concepts of authority and power and governance. And so, but the territory is there. And then when they get to the very last sentence in the McGurk decision, what does Gorsuch say? He says, well, Congress hasn't taken that territory, but under their plenary power, they can do it anytime they want to. They do it tomorrow. And so the plenary power was affirmed. So in the most recent Indian law cases that have come down to the U.S. Supreme Court, they've affirmed the plenary power doctrine, which comes under the trust relationship, which comes out of the doctrine of discovery. And since that decision, McGurk decision then, and a Castro Huerta decision and some other ones, they've gone ahead and said, well, in the case, let's say in the case of the Cheyenne and Arapaho. Cheyenne and Arapaho, used to be near me down in Colorado until the Sand Creek Massacre, right? And then they forced them into a treaty after the massacre and said, you got to sign this and move down to Oklahoma. And we're going to pay you reparations too for the massacre, which they never did. They never paid the money. Kicked them down into Oklahoma. And then later on, just a few years ago, last year, I think, the Court of Appeals in Oklahoma ruled that because of that treaty they signed and the agreement they signed to move down in Oklahoma, they no longer exist as a reservation. They do not have territory. And they've gone and said that now for 3 other tribes in Oklahoma that were forced to move there. So they have no land. They have no territory of their own. They have no they have no domain, which you need for sovereignty. And so this stuff is new. It's still here. The doctrine of discovery is still here. So that's what that's about. All right. So I've already been through these things. I'll show you. Now, normally when you're a nation, you have what's called a domain, a territory. And that's what this discussion is about. So the They changed, through federal Indian law, this, trying to make it all legal, this is lawfare. They changed territory for Native people from a territory. Canada has territory. Mexico has territory, right? If for Indian people, they have a reservation. And if you read the federal Indian law, they say, well, Indian people did not reserve that land from cession. The United States reserved that land to the Native people, like the United States owned it in the first place. And they're the benevolent dictator that they're going to give them their land. So that's like somebody telling me that they're going to give me the house that I own, which I don't own, the bank owns it, but they're going to give me the car I own, for example. And I'm saying, well, I already own it. Said, well, that's okay. I'm going to give it to you anyway. And you should be nice and thankful for that. So, and then when they did that, not only that, what the McIntosh decision says, these decisions that going back to the Doctrine of Discovery, when they said Native people could not own this land and that they were going to own it, what do they do with the Native people that are occupying there? Well, they say, well, we're going to be nice and we're going to recognize the right of occupation. So even though they were saying the land was unoccupied by Native people and they could come in and take it, then they turn right around and say, well, we're going to recognize that they're occupying the land and give them a right of occupancy, which is basically a life estate. It's saying they can stay there as long as we let them. And that's what you find in the litigation now on Indian law. So it's a law of, and so really what we're looking at, we call this federal Indian law, but it's really not federal Indian law at all. It's international law. It's a law of nations. It's colonial law. It's what happens when one dominant nation comes in and they take over other nations. What is the law of that? That's not domestic law. That's international law, the law of nations. The United States Supreme Court should have no business at all construing any treaty between the Indian nations, Native nations, and the federal government. There's no business. You don't have one party to a treaty come in and say what that treaty means and have it binding on the other party. You can't do that. Under the law of nations, then we, even Western law there, we have the Vienna Convention on Treaties, and that's decided at the international level. So all of these U.S. Supreme Court decisions construing any treaty with any Native nation is illegal under international law, including the Oceti's international law. That's the law I'm talking about. They even wrote that the colonial nations that invaded Turtle Island are the same ones that wrote these international laws, and they did it to control their relationships between themselves. But once you recognize Native nations as nations, then they get the benefit of these laws themselves. And that was their mistake that they made. And so now it's being used. So the trust doctrine was where they classified Native nations as domestic dependent nations. Of course, they're not really nations. They call them tribes, which is this. And I've been through this stuff. But that plenary power doctrine then was used to take all of the lands, all of the lands. It was used in the Sioux Nation case that took the Black Hills. It was used in the 1889 Act that broke up the Great Sioux Nation into the reservations we see today, to take all the what they call surplus land, is the land in between. It was used to enforce allotment. It was the plenary power. And that all comes from the Doctrine of Discovery. The only reason why they have plenary power is because they say that Indian people are living on the land of the United States, not that the United States is occupying the land of Indian people. So, yeah.
United States.
Where is it? That's probably under our feet. Yeah, right. It should be over in Europe is where it should.
Pacific Ocean, north and south.
Yeah.
Of all indigenous people.
Yes.
There's no room for United States.
Yeah, yeah. You're right. But their whole program here is, well, in colonial, what we call settler colonialism. That's a really nice way of saying, oh, the settlers are coming out there and they're looking for a home, right? But settler colonialism means that they have to move the people out of the way so that the white people can come in and take and have a place to live. And so that's called extinction. Settler colonialism is also a form of genocide. And so erasure. So the ultimate goal is the genocide of indigenous people. We see that happening right now in Palestine. The ultimate goal of the Israeli government is to remove all the Palestinians from their homelands. That's what's going on right now. All right, so the law of nations. And Phil asked me, and I'm sorry I spent so much time on this, but it's necessary. What can we do right now? As a lawyer, what would I say we can do right now, right? This is a law that was established 200 years ago, on the 200th anniversary. Number one, you stand on your treaties, because one of the presenters yesterday was talking about Section 6 in the U.S. Constitution. Their own law says that they have to obey treaties that they sign, that they're supreme laws, all right? And then that has to be construed at an international level. Treaties are not construed by the U.S. Supreme Court. Under their law, that should be construed by the Vienna Convention on Treaties. And then colonization is a matter of international law, that Native people have a right of self-determination under international law, and they have a right of equality of all nations and peoples. We're all equal. So every Native nation, every Indian people are equal to all other peoples of the world, to England and everything else. So we have this. These are the arguments that have been made for self-determination. The other thing that's happened is, beginning after the Second World War, they developed this process of decolonization, of liberation. So they had national liberation struggles, but all it did was substitute one colonial power for more local colonial power. The United States is a more local colonial power that's substituting now for England, France, Spain, and the Netherlands, the Dutch. I'm sorry, Denmark. So, but that's been condemned now. We're now in the 4th international decade for the eradication of colonialism. So as a matter, this is why federal Indian law in the situation today is illegal. All of this stuff is illegal under international law, because they've called for the end of colonization. They recognize it as a fundamental violation of human rights. And so they have these resolutions here that passed by and the UN General Assembly is the Congress of the world. And so they do that. So they pass a law, they pass a resolution every year calling for the end of colonial rule. And in the UN Charter, there's actually a whole 1/3 of the Charter sets up a process for ending colonial rule. But the strange part about it, and it's happened here, there's been a couple of cases now. This is where they should be heard. The International Court of Justice, for example, ruled in 1975 that the doctrine of discovery was horrible, and they tossed it out. They said it was no longer a valid law, and that was in 75. And then more recently, with the Chagos Islands case, they also looked at colonization and they tossed it. The United States was actually part of that. It involved a dispute over the rights to an island. In the Alapamas case in 1929, they said you can't have colonial rule over a land that you don't occupy yourself. And then there's been several decisions that have held that the colonization of people is racist, right? That the only reason why you're being colonized is because you're native. You don't see them colonizing other white nations. They only colonize indigenous peoples in Africa and the Americas. And so there's been a couple of cases on this. There's law on this that says that that colonialism is racism. Actually, in this International Convention on the Elimination of Racial Discrimination, that the United States has signed and ratified. This is the law of the United States at an international level. They have not put it into its domestic law and implement it, so they say they don't have to obey it. But in the preamble of this international treaty that's been signed by most of the countries of the world, it says that colonialism is racism. And then there's been a couple of decisions, one at Australia, the High Court of Australia, the Mamo v. Queensland, that quoted the Western Sahara case and discarded the doctrine of discovery in 1992. And then you have the Inter-American Commission on Human Rights, and the Western Shoshone took a case there, the Dan sisters. And in that case, they also said federal Indian law is racist. And then I have a case pending right now. This is my case. It's for the Onondaga Nation in the Haudenosaunee Confederacy. And in this case, we got a decision, like the Dan case, that ruled that we have a claim for 2 million acres that were stolen from the Onondaga people in New York 200 years ago. 200 years ago. And so they're saying the United States is racist because they're not giving a remedy for Native people to be able to claim their land. Sound familiar? That's the Black Hills. And we do, the Oceti Sakowin were not given a remedy to get their land back, just money. And so this case is challenging that. And we just filed a brief, it's one I authored in this body, where we're directly challenging the colonial relationship. We're saying the colonial domination of the United States over the Onondaga people is unlawful, wholly unlawful. This is the first time I'm aware that there's been this head-on challenge to that. So I'm going to stop there in terms of the slides here. But trying to design how do we go about this? As a federal Indian lawyer, I would say, well, the United States has overturned decisions that are old. When they just outlawed abortion, right? That overturned a decision that was 60 years old. In the United, what was that? Citizens United case, that ruled that said that corporations were people, and therefore they had the right to, they had a free speech right and could invest all their money in these elections, that they can buy elections. That was based on a decision in the U.S. Supreme Court that overturned a law that had been in existence for 100 years, right? So I think because of the changes at the international level, some of the stuff I just went through, and because of the development of international human rights law, which didn't exist in 1823, right? That you can go into federal court right now and challenge the doctrine of discovery, challenge the relationship, the domination of the United States over the Oceti Sakowin or over the Oglala Sioux tribe of the Cheyenne River. Whoever you wanted to, you can go in now and challenge that, I think. And have an argument. They'll throw you out initially. It'll have to go all the way up to U.S. Supreme Court, because all the lower courts will say we're bound by this Supreme Court decision from 1823. But once you get up there, then you start making all these arguments, and you push them in a corner, and they may have a hard time. This happened in Australia in that Mamo case I told you about. That's exactly what happened, and they won a half victory. I can go into that more if anyone's interested. But I think you'll ultimately lose in the Supreme Court. They'll find some way to wiggle out of it. And they're not going to end the colonial domination under the doctrine of discovery. They're not going to say that this is Indian land that we're on right now. They'll continue to say that Indian people are squatters on the land of the United States. Right? That's what it is. Right of occupation is you're squatting on the land of the United States. So ultimately then, to really challenge the doctrine of discovery, and this is going to get worse now because of the makeup of the Supreme Court, right? It's a lot worse. But ultimately, if you really want to make any progress on challenging the doctrine of discovery, it has to be done with the Wasatchu's international law doctrines, challenging it like they did, like we're doing for the Onondagas. Hopefully we'll get a good decision out of that, but that's kind of where it's at. So I don't know if Phil's still around or what he wanted me to talk about, but that's kind of it, if somebody had discussions. Yeah.
As I said earlier, I really like the fact, first off, you're at the United Nations level. I understand that clearly, like lack of education for federal law is no excuse. Am I correct? Yes or no?
What now? Lack of education?
Lack of education for federal law is no excuse to those who study federal law.
No, you're expected to know the law.
When you study the law, if you study federal law, lack of education is no excuse due to the fact there's grade school, high school, college, universities, correct?
Right.
Okay, so I was looking on my phone, and in the education that I did over the last 20 years, the Clearfield Doctrine, it says that corporations cannot have a say over sovereign nations. This is the United States Corporate Charter number. I'm gonna read it to you. And I'm gonna ask, why hasn't this number ever been brought up in federal court because if you, corporations cannot supersede a nation. The United States corporate charter number is 062714 That's like McDonald's or Burger King. Am I right?
Well, it's considered a corporate entity. Yeah, you're right on that.
Okay. So,
Now, the people are not incorporated, but the people incorporate their government is known as a public corporation. Yeah.
United States, when it went bankrupt in 1933, it became a corporation. That corporation went bankrupt. Roosevelt fired Congress. Okay? And we have never asked that question. And when I asked that question at the United Nations level, I was kicked out of the United Nations. When I asked that question in Washington, D.C., I went to jail. And when I stand up, it's a really awful feeling to tell you what it's like to be homeless in your own land, jobless. People hate you, and a feeling that you just want to, like for me, I just want to not be around, because I often wonder, you're a lawyer. You're an international lawyer. And you're telling our people these laws, and they're great, and it's really nice to know. But that charter number of the United States, why isn't that being challenged at the United Nations level if that's where you take care of things? And Geneva, Switzerland, World Court, because United States corporation, yeah, we could go all through these court cases one at a time, but there's, in my studies, I found some laws that corporations used against the United States that they couldn't supersede. I can bring them up if you want them, but I don't mean to be angry or mad at you. I'm not mad at you. I'm mad at the system for failing our people. I'm mad at the system for destroying our future's life, our future children, future generations' lives, lying to our elders and manipulating our people at every level just for some money, while the rest of our people struggle on food stamps and commodities and contaminated food. That's why I'm mad. I asked God. I went to Humblecha here at Bear Butte, and I asked to go home, and they told me to wait because they had an answer for us. And as an educated man, I just want to know, will you please address the United States at the United Nations level, that corporate charter number, and not get kicked out? I got kicked out for asking that question. My two sons, matter of fact, I think one of my sons was politically targeted and killed because I was an activist for Indian country. And I regret that with my life, because I was already told by our ancestors, if we stood up, that government would kill us. And I wish I didn't. I wish to God that I could save my son. I wish that I could help my people to live. But you come here and you tell us about these laws. And I didn't give up. I just prayed that one day, will give you the courage to question that government about their charter number, and who give them authority. That's called Cubarrento in Spanish. Cubarrento means who give you the authority to supersede Indian nations with treaties all the way around the world, especially if you're bankrupt. With a corporate charter number like McDonald's and Burger King. Who give that authority? Who's given it? And why?
Well, nobody gave them that authority. They took it. That's the issue.
Okay, but the question is, like, if you was the government, I'll say Cubarrento Why? Who give you that authority to supersede our treaties around the world?
Nobody.
Exactly. So why is the United States bankrupt corporation able to make rules according to the 1933 bankruptcy? There's the 16th American jurisprudence that says you cannot write laws just to be writing laws to supersede anybody. So who's giving you that? Who's allowing that to happen? I mean, and you know what? No one's asking this question. Nobody. At the United Nations level, around the world, nobody. I came here because I wanted our people to know. I stood up, I tried, and not just one, but two of my sons died. And you're right, our grandmothers and grandfathers were right. If we stood up, they would destroy us. Make sure we were homeless, make sure we were jobless, make sure that we didn't have nothing. And that's where I'm at right now.
Okay.
And the rest of you are all lucky, but I really wish, I hope, I pray for you to ask that question. If you're gonna represent the Indian nation, then represent you have and go full force. Don't do us dirty. Uh-huh.
Uh-huh.
Go ahead, Chitelo, Madakya, Oyasu.
We'll pull out.
All right, just wanted to kind of reiterate a little bit, that it takes a collective of our people in order to address issues. And lawyers, we utilize them, they are our voice. And if we don't utilize them and we don't come together and unify and address these issues, then we're really not solving anything of our homeland. And the other thing about that too is we really need to realize that we need to let the parakeet out of the cage. And what I mean by that is we keep on citing things that they created in order to keep us oppressed or keep us thinking about the laws. The parakeets always recite this Constitution, they recite the policies, they recite everything. But if we were really to take a stand, what little homeland we have, we need to make our own home rules and create it so we can have our own form of understanding and laws. If we don't do that, then we continue to have BIA, Indian Affairs policies, their circulars, their constitution that they have. If we don't take a stand, then what are we gonna do with what little we have? And I think the first thing of order is that I was trying to get Phil to convince him. Declaration of our independence. We're free. We haven't done that yet. We're still we got tribal membership and we got enrollment numbers and, when are we going to actually say, hey, we declare ourselves free? But we don't. So we'll still have our tribal membership. I want to bring aboard Water Resource, and that will be Reno Red Cloud and Doug Road Ghost. Both of them will come up. They're here. They're coming up. Old scout trick. Yeah.
He does the share screening. That's okay, we're all right. Hello, my friends and relatives. How are you guys doing today? Doug Crow Ghost, Standing Rock Sioux Tribe, Hunkpapa Lakota. I'm my dad is from Bullhead, South Dakota, and my mom is Winnebago and Meskwaki. So I'm a mutt mixed, and I got a lot of fighting vigor in me. Protecting the Missouri River and the aquifers of our people. 60 million acres of land is our treaty, is our rights. And that is one of the charges of my life. Today, we're just gonna just really quickly give a quick update on what the Great Plains Tribal Water Alliance is doing. The Great Plains Tribal Water Alliance is technical advisors to the Great Plains Tribal Chairmen's Associations, and when there's appropriations or there's water grabs that are going to the states and that are being sold, it's our treaty water right that is being sold and taken. We are here to protect that. And what we do is we let the chairmans know to take it to Congress, to take it to the Hill, and let them continue to fight for what is rightfully ours. And that's first in right, first in time. One of the things I'm just going to quickly talk about is quantification. What quantification is a bad thing or is it a good thing? For many decades, quantification has been something that our relatives have not and does not want to do. Quantification has a bad connotation of allowing for a number to be put on our water right. What's happening today in 2024 is the water is being diverted for projects, oil and gas, and also for population growth in the West. The water that is being taken for population growth and development is not only by the states, but it's also by corporations and some tribes. If you quantify your water right, what you're doing is you're letting the government know that you cannot touch this amount of water, be it groundwater or surface water. Now, to some tribes, that's good, especially if you have oil development or development of some sort of extraction. Some of our relatives up north, some of our relatives to the west are using their water right, and they're quantifying for extraction. So what we're trying to figure out and what we're trying to continue to tell our relatives is, do we as a whole, especially the Lakotas, Oceti, Sakowin, and the tribes of the Great Plains, 60 million acres, do we want to do that as well? And the thought is, no, we don't. So the information that we give our tribal leaders is the information of the why it isn't good to quantify, like our relatives in Montana. So what do we need? What do we want to do? And so we go to our relatives, we go to the communities of our tribes, and we ask, what do you use your water for? How much water do you need? Because one of the things is we're seeing is that municipalities in our tribes, within our tribal homelands, are starting to sell water to our people on tribal lands for infrastructure, for use. And we're trying to protect that. So what the Great Plains Tribal Water Alliance is doing, and I know Reno's going to talk a little bit about some other issues real quick, is we just want to continue to protect the water resources, our first water, and the rights of many Wachoni for all of our relatives and the ones not born. The last thing I'll give a quick update is some of you guys might want to know what Standing Rock's doing with the Dakota Access Pipeline. There's been a filing in the federal courts called Standing Rock versus the Army Corps of Engineers. What we're finding now is that 17 states have intervened with the Army Corps of Engineers against Standing Rock. 17 states. Standing Rock is up against not only the Army Corps of Engineers, but now a bunch of states. Now, we're not scared of them states or the Army Corps because we have a solid case. But in 2017, we had over 15 to 20,000 relatives from all over the world come to Standing Rock to help protect the Missouri River. I don't know where they are all now, but I know that in your hearts, you're still a water protector. Everybody's been a water protector, and there's still millions out there. If you have any, if you would like to re-engage and understand what Standing Rock is doing, I would suggest that you go on standingrock.org or contact me. Doug Crow goes to Standing Rock Sioux Tribe. I'm the Water Resources Director. We are looking for, and this is my last thing I'll say is, we're looking for individuals and tribes and to help us with our legal fight. If other tribes want to intervene, they're more than welcome to intervene with a court case. We would love to see all of the tribes intervene in this court case. The problem a lot of times is when you get your lawyers involved and you get too many, then there's always issues. I always have, is there any lawyers in there? Before I say the joke, there's no lawyers in here? I was gonna say, what do you call 20 lawyers at the bottom of the sea? A good start. A good start. Yeah. Anyway, it's a joke. I think some of you guys understand that. So anyway, I'll just leave it at that. The Great Plains Tribal Water Alliance is continuing to protect the water rights of the Oceti, Sakowin, and the people and our relatives that are not yet born. The first medicine of our people is always going to be water. It's not just surface water, but it's also groundwater. The Oglala aquifer and the aquifers that are located inside of your treaty lands and in your communities are very important as well. They're being desecrated, and they're being there's a lot of arsenic in your groundwater right now, especially in the Black Hills. And right now, there is a proposed pipeline for water from the Missouri River to the western South Dakota. It's called the Western South Dakota Water Pipeline. What they say is that the population of the western South Dakota is going to increase, and there's going to need to be more water, i.e. the Air Force Base is supposed to get big here in Rapid City. They're also using numbers of our relatives from Pine Ridge and from other tribes, saying that the population of western South Dakota is going to increase, so there needs to be fresh water from the Missouri River pumped all the way to Rapid City. What we know to be true is that there is enough water in the ground to support the population growth without using our relatives' numbers. The problem we see is that the groundwater is being contaminated with mining. I think we had a mining, I don't know if the mining, what's her name? Yeah, Lilias. Oh, there she is. Hey, Lilias. Yeah, Lilias has all the information, but the mining here in is just incredibly bad, and it's affecting the groundwater. So South Dakota is going to tap into the Missouri River and bring some fresh water to Rapid City. And we know to believe that it's not going to just stop here, but it's going to go towards Wyoming and maybe down to Colorado. So it's a water grab by the states, and they're going to sell that water. Now that's native water. It's not water that we own, but it's water that is right to us first. And we know that this $10 million, well, actually it's going to be $1 billion project, but 10 million just for the planning. That money can go to tribes for infrastructure to get clean, fresh water out to our people in the tribes, in the reservations. So we oppose the Western Dakota Pipeline Project because the money can be spent better for the population of our relatives and indigenous population here in the Oceti Sakowin area. So that's just one of the other updates. With that, I'll go ahead and turn it over to Reno, who has some better information, hopefully, than I do. Plus, he looks better than me when he's talking.
Okay, good afternoon. My name is Reno Red Cloud. I'm the Oglala Sioux Tribe Water Resource Department Director. I am the sixth generation of Chief Red Cloud. My dad is Reno Senior. My grandfather is Edgar Red Cloud and Lottie Bitsnet. My grandpa Edgar's dad is James Red Cloud. And his father is Jack Red Cloud. So then Jack's the oldest out of Chief Red Cloud. I go off my family tree, but I am the sixth generation. I know I'm probably a new face amongst the treaty group, but I've been active in water. I started in 1978 when I got educated in California, but I came back and I've been active in working for the tribe for over 35 years in water. So, but today I wanted to just give you an update that, you know, since the historic days of the treaties, you know, the 1851, 1868, back then the boundaries of the treaty lands was all based, a lot of it on water. Missouri River, Powder River, Platte River, up north, because we followed the buffalo. But today, you know, we got to be looking at it in a realistic perspective, because, you know, from 1851, 1868 to now, we had to adapt. And yet we're going to look at adapting again, because right now, I think we're in a critical phase of fighting and protecting our water rights because of this new administration that's coming in with Donald Trump. But I just wanted to kind of highlight that I do the water code for the tribe, and I do work actively with a lot of other organizations within the Black Hills. And we're active in protecting the treaty water resources. One of them is the Cheyenne River, the White River. These have been polluted, contaminated by mining. You got uranium mining, you got gold mining, you got all this mining going on in the lithium mining in the Black Hills. You got Crow Butte down south. I'm glad that Mr. Andy Reid and them were effective in looking at getting that stopped. But, you know, the fight's there. You know, we've got to come together. I'm glad I'm here at the Treaty Council because, you know, there's always discussions of the treaties of 1851, 1868, the traditional government, traditional ancestral ways. And then in 1934, you got the IRA government coming in. So that took the tribes in different directions with the government funding. And, you know, we got to really look at where we're at today. We got to integrate the traditional, the IRA governments. We got to come together. Now's the time to unite, not only, you know, for our historical, cultural values, but, you know, our existence. You know, we're upstairs with a group and we're talking about, you know, water rights, because we're looking at a defense strategy for Project 2025 because of this new Republican government comes at us and says, okay, look at the tribes, look at the treaties, look at the sovereignty. We're going to have to come up and fight and say, okay, these treaties are Article 6, Supreme Law of the Land. nation to nation. You can't just come in there and have a bunch of insane politicians come in there and try to take out a culture that was here before they even stepped foot here. So we got to, really come together. And there's a lot of tribal people. I'm glad I'm working with Mr. Krogost here with the Great Plains Tribal Water Alliance, because we do our best to protect treaty water. He was active with DAPL up there in Standing Rock, and right now I'm trying to keep our head up with the mining going on in the Black Hills. So there's a lot of fight out there, but I think it's time now where we really, look inside and say, okay, let's identify the issues of today, which is Project 2025, the political system. It all goes back to capitalism. It goes back to greed. It goes back to money. When the white man came, he seen the mineral, he seen the forest, he seen the water, and all he seen was dollar signs. That's how they became rich. They were all immigrants themselves, and yet they're keying on the southern border with our relatives down there. Because the Mayas and the Aztecs, though, they're Native American too. They're indigenous. But, right now with Indian water rights, the big picture is you got the treaty water rights, 1851, 1868. We had them, Missouri River, all the tribes. We had water projects developed out of them. Minnewachuny, where the Oglala Sioux tribe was one of them. And that was based on trust responsibility to provide drinking water to the Pine Ridge Reservation due to poor water quality in the northern part of the reservation of Red Shirt, Rocky Ford, that with high well water contaminants of arsenic, uranium. So the natural occurring elements are here. But, I'm glad that our tribal officials had the foresight to get a pipeline built off of a treaty water resource off the Missouri River. So, and then Lower Brule and Rosebud worked off of that too. And they got the West River Lyman Jones because anything that's in the Badlands area is clay soil, and it's, whatever water availability you do get into the wells, it's going to be high levels of arsenic and uranium. So, piping this water in was a solution. It was identified, it was responded, and it was resolved with using our treaty water resources. But today, one of our identifications is we got our sovereignty, we got our treaties, we got our, our protections, but we really got to look at 1851, 1868 to 2024. We really got to come together. We got different, structures. You got our tribal historic preservation offices, which the THPO should be out there. We should have them unite, just like how we're uniting with the Great Plains Tribal Water Alliance to protect our treaty water rights. So, but just today, I just want to just let you know that as far as the great, with what we're doing is we're looking at a strategic plan to preserve our source water, and looking at, litigation or legislation, whatever avenue we could take, because I know that in the long run, it's going to be the legal status of the tribe. And I think now is the time where we get some of our attorneys together and unite all the attorneys in the Oceti, Sakowin, like with the IRA governments and different ones, to come together and come up with a strategic plan that, okay, if they come at us, here's our response on a legal aspect, so legal venue. But I just wanted to let you know that, through my position, I'm doing my best to protect the treaties, the water Right now, I just put in a grant for water quality study on the Cheyenne River. Off of that grant proposal, if I do get the funding, it's gonna be water sampling in the Cheyenne River for uranium detects, which we already know there is. That if we do get the detects and we get the report from this water sampling grant, that we're gonna take it a step further and take it to the government and ask them, okay, we did a 2024 water study. You got uranium in this water. Now let's clean up the mines at Edgemont, South Dakota, because there's still open pit mines over there. There's still 1,300 drill holes that need to be covered and filled in those holes, because it's a annual contamination cycle of those open pit mines. Every year it rains, every year it snows, melts off and it goes right back into the Cheyenne River. So I think, we gotta use our youth, use our academics with our children, our ones in college, and utilize them as our future leaders, our future protectors, our future scientists, our future environmentalists, our future traditionalists, our future protectors. But that's just mainly my report for today. And if you have any other questions, you could feel free to contact me. And my office is in Pine Ridge, OST Water Resource Department. Thank you.
I just wanted to let Reno and Doug know that the treaty councils are also working on a document for addressing 2025. So we need to synchronize our efforts. But I want them to know that the key to 2025 is to guide our Oyate to self-sufficiency. That's the number one weapon. We're so dependent on the federal monies that we got to go back to who we are, inherent sovereignty in the treaties. Thank you.
Okay, we're gonna break for lunch. Our relative is gonna say the prayer. And just wanted to mention, we talked about many of the ideas of governance, but you got to remember one thing, 4 things that govern a society that creates a movement is food, shelter, clothing, water. Now, those are the things that we really need that creates, if you talk about food, they talk about food sovereignty. That's what creates society. Water, we need water to survive. We need some form of shelter to keep us out of the elements. And land. All of these things are really what governs any society, whether it's a traditional or the modern European model. And that's what really created a lot of changes. They needed water. They needed a raw material. They needed land. They needed that. We also had that. So it was taken from us. So when we talk about reorganizing, those are the guiding principles of a human being. We need those. So if we're going to reorganize, that's the principle. We need to start looking at it that way. As when this treaty council is over, I got to go back and go back to eating bologna sandwiches. I was really eating good up here. I went out and drank sodas for the first time, donuts, and I thought it was like a dream come true. From the res. I said, boy. I even went to. They even gave me a little gosh poppy to go over to McDonald's. So I said, yeah, I'm happy now. So I don't have to. But when I get home, it's back to bologna sandwiches, and hopefully there's still some flour to make some bread and a little bacon grease left over. I can dip that and same. I even got a little bit more chubbier. I really felt good about that. So, all right. So I want to offer that opportunity for
Tashi, before you let go, Chesapa OTP, come back at 1 o'clock.
Yeah, 1 o'clock.
Okay.
Come back and you get to. So 1 o'clock.